Good afternoon. It's a privilege and a pleasure for me to be a part of this summit by the Department of Justice on freedom of expression and data privacy on social media. Now, my task today is to talk about freedom of expression on social media, rights and remedies in the Philippine legal framework. Part one deals with established doctrines that are being challenged by the new circumstances. And here we would look at our current international commitments, how these commitments are understood under our constitutional commitments. And we will also look at the established model of free expression regulation. Part two then looks at the challenge to free expression that the rise of social media has presented. And we will look at the technological developments that have made this possible and their unintended consequences. Finally, part three will look at possible approaches to use for understanding the transformations that have taken place as a result of social media. How do we now understand free expression regulation? We will go all the way to developments in the Philippines with respect to jurisprudence as well as to our international commitments. And then I will conclude the presentation. Now, on to the first part of my presentation, established doctrines, new circumstances. We are all familiar with Article 19 of the International Covenant of Civil and Political Rights. And this is really the cornerstone in international law of the right to free speech and the right to free expression. Article 19 provides that everyone shall have the right to hold opinions without interference. Everyone shall have the right to freedom of expression. This provision enumerates all the corollary rights to the right to freedom of expression. And finally, the third paragraph talks about possible limitations, which limitations shall only be such as are provided by law and are necessary. We had our top-notch diplomats of the time, Carlos P. Romulo and Salvador Lopez, who were former journalists, and they were instrumental in the shaping of the ICCPR as an international bill of human rights. And Salvador Lopez, in particular, pushed for the establishment of an optional protocol for the ICCPR. And this optional protocol established an individual complaints mechanism. And as you can see, with respect to the ICCPR, we were among the first countries to sign up to it, although it took us some time to ratify the ICCPR. With respect to the first optional protocol, we were also among the first to sign up to it, but we only agreed to the optional protocol, the first optional protocol, much later. In fact, 3 years after the EDSA revolution. We're still the only country in the ASEAN that has actually become a party to the first optional protocol. This protocol is important because under this protocol, any Filipino citizen may file an individual complaint before the Committee on Human Rights against the government for any alleged violation of the right to free expression. Let me now go to the constitutional architecture that embodies these international commitments. And the Philippines being a former colony of the United States, we imbibed a lot of the traditions, a lot of the philosophical and jurisprudential history of the United States. And a leading case that I will refer to now, Whitney versus California, to my mind, encapsulates the Philippine understanding of constitutional protections with respect to free expression. And it says the framers of the Constitution knew that order cannot be secured merely through fear of punishment for its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones. And here you see really this commitment to a freewheeling and open discussion of public issues, that it is better for the government to allow discussion rather than prohibit it, because it is in these discussions that uh, citizens find political, social, economic, or even spiritual enlightenment. And such enlightenment is essential to the building of a strong state, of a strong government or even of a strong society. And so, on the basis of this design, we have in our own jurisprudence formal legal and constitutional protections on free expression that are focused on individual rights. And these are framed as guarantees against state encroachments into individual spheres of freedom. And let me look at three or four such landmark cases that have defined for many generations what we understood to be um, at the heart of free expression in the Philippines. And here we read the Supreme Court saying, in the hierarchy of civil liberties, the rights of free expression and of assembly occupy a preferred position as they are essential to the preservation and vitality of our civil and political institutions. And such priority gives these liberties the sanctity and the sanction, not permitting dubious intrusions. The second case is People versus Marty, and here is an ironclad protection given by the Constitution to the individual against state encroachment. And let me read this important passage from People versus Marty. First, the general reflections, the protection of fundamental liberties in the essence of constitutional democracy. Protection against whom? Protection against the state. The Bill of Rights governs the relationship between the individual and the state. Its concern is not the relation between individuals, between a private individual and other individuals. What the Bill of Rights does is to declare some forbidden zones in the private sphere inaccessible to any power holder. A third case is David versus Arroyo from 2006. And here the court said it is that officious functionary of the repressive government who tells the citizen that he may speak only if allowed to do so, and no more and no less than what he is permitted to say on pain of punishment should he be so rash as to disobey. Freedom to comment on public affairs is essential to the vitality of a representative democracy. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Now, all these cases presents us with the picture of the state um, regulating directly the speakers. That is really the 20th century dyadic model of free expression regulation. And that has been the prevailing model for a long time since the dawn of the mass media system. But with the rise of social media, we are beginning to see that this model of free speech regulation, it's no longer able to account for the many transformations that have taken place since the development of social media as a mode or means of communication for billions of the world's populace. We have, for example, Facebook, Twitter, blogging platforms, YouTube, of course, and other such social media networks. So I will now go to the challenges that are presented to us today as far as the regulation of social media is concerned. What are the particular issues that have arisen from the development of social media at this stage of human history? Now, the first one is that we see social media enabling the free speech of potentially billions of people. So right now, there are almost 4 billion people who access social media around the world, and that's 50% of the world's current population. And corollary to that is the observation that, in fact, the global reach of big tech is now more extensive than by that of any state or even of any international organization. At any given time, people are able to share what they have in mind about a particular question. Last year, I participated in a consultation by Facebook for the establishment of the oversight board, and in one of the sessions that I attended in Singapore, we were told that any given day, uh, as many as 200 million images are uploaded to Facebook. So imagine, of course, the free expression questions that arise out of each of those 200 million images that are uploaded to Facebook at any given day. And that leads me to my third point about the transformations that have come into play as a result of the rise of big technology. big technologies, technical capabilities are such that they actually exceed what most states are able to do by way of surveillance. And these technical capacities really are the backbone of social media's business model of surveillance capitalism. No? So Facebook needs to know what your interests are. Facebook needs to know what sites you visit, and on the basis of artificial intelligence, of algorithms that its engineers have designed, they will be able to make a profile of each member, so that if you click this site, it will tell Facebook that you are fond of buying fountain pens, or you're fond of cars, for instance. And on that basis, it will then funnel to your feed products that it could sell to you. And with this, we can see just how powerful social media companies have become. They have a reach that no single state could match, because their influence, their membership straddles many countries. Quite possibly, we can say that in every country in the world, they will have a huge footprint. And and the rise of social media and their technological prowess have, of course, resulted in unintended consequences. I'm going to discuss just five of these unintended consequences. First one is free speech by algorithm. Instead of facilitating discussions between and among disparate groups of people coming from different political persuasions, what happens is that you will be grouped with other people who share the same opinions. So rather than actually facilitating an exchange of ideas, what happens is that people are placed in political bubbles. And according to German philosopher Urgen Habermas, in a very insightful essay written in 2006, um, as a result of that, what we have is a post-truth democracy. And such a democracy would no longer be a democracy, ironically. And in 2006, a remarkable development, and this was actually the elections of the American elections in 2006 that paved the way for George W. Bush to become president of the United States. According to the philosopher, you saw all these Americans voting no matter what. They were not concerned so much with what the facts are, but whether or not the facts as presented are actually congruent with their own political persuasions. A second terrible and dangerous effect of the rise of social media is death by speech. And there's probably no more horrific example of that than what happened in Myanmar, where um, where the government there is alleged to have perpetrated or encouraged genocide. All these government functionaries in Myanmar allegedly sharing misinformation to spur genocidal acts against the Rohingya. A third unintended consequence is political manipulation. An example of that would be Cambridge Analytica allegedly using the Philippines as a laboratory for its new techniques for mass persuasion using social media. A fourth unintended consequence is political polarization, and we're not stranger to this. And what's so alarming about this is that on the basis of political differences, it has become very difficult now for citizens to imagine living and working together with people who belong to a different political persuasion. A fifth unintended consequence is the possibility of foreign political interference. And Facebook, a couple of months ago, announced that it has removed 155 accounts, 11 pages, 9 groups, and 6 Instagram accounts, which exhibit coordinated inauthentic behavior on behalf of a foreign or governmental entity. Because according to Facebook, this activity originated from China and targeted the Philippines and Southeast Asia and even the United States. With these new developments, some international legal scholars have proposed this Oxford Statement on International Protections against foreign electoral interference through digital means. I will just read here the fifth paragraph of the statement. The full text you can download from the internet. It says states have an obligation to protect and ensure the integrity of their own electoral processes against interference by other states. To discharge this obligation, states may be required to put in place electoral security measures such as legislation and backup systems, as well as to secure the availability of public, timely, and accurate information on electoral processes. Any restrictive measures taken by states that interfere with human rights must be in accordance with applicable legal requirements such as legitimate purpose, legality, necessity, proportionality, and non discrimination. Now, this leads me to part three of my presentation, the new doctrines for new circumstances. Previously, we said the long prevailing model was the YADIC, where the state just went directly for the speaker. But that was when you had legacy media, or you had people writing for newspapers, or people marching out in the streets. But today, you don't need people to march in the streets to have millions of citizens airing their opinions on a current issue of the day. You only have to go to Facebook and see how all these opinions are circulated, are passed on from one side, one page to the next. Um, and therefore, we have to reimagine free speech in relation to social media. Now, one proposed model is what we call the triangular model of free expression. And you can see in this inverted triangle a new pillar. Whereas before you only had a dyad, you had the state and the speaker. Now you have a third leg. So on the first side of the triangle, on the left, you had this classic old school speech regulation that we have just described, and on the right, and you have a new dimension where you see end user citizens, civil society organizations, even new media, or even legacy media having to go through social media, through these infrastructure providers, search engines, web hostings, ISPs, domain name registries and registrars, caching services, payment systems, standard setting organizations, hackers, and trolls were viewed as censors. So on the right, you have this classic government regulation. On the left, you have the private governance systems that are developing, and and there's an interaction between these new non-state actors that now play an active role in free speech regulation uh, through different modes of private governance. And of course, the upper side of this inverted triangle, you have this interaction between governments, even international organizations, and these social media platforms and the like. And that is what we call now the new school speech regulation. Sometimes there's co-optation where governments are able to successfully control the way in which a social media platform carries out regulation, private governance regulation. At other times, all that the government is able to do is to have some form of cooperation. But these two elements are what you will find in new school speech regulation. Now you have this triangle. And how does this happen in real life? You look at this grid, the left side of the grid, that's the traditional dyadic form of free speech regulation. While on the right side, you see the current developments that are taking place with respect to all these social media platforms. So you have states and even international bodies, they make certain arrangements with these platforms that enable speech by billions of people. So here, there's a third element that was not there before. The social media platforms are not government, but in some way they carry out their own regulation that used to be carried out exclusively by the state. Not only that, but they have actually developed their own mechanisms. So you have what is analogous to government administrative prior restraint now being implemented by social media platforms. What you see there is a news article about backroom offices in the Philippines being paid to help weed out undesirable content. You know, what they actually come across are horrendous images and videos that no sane human being should actually access in his or her life. One of the responses made by Facebook is the creation of an oversight board, purportedly to ensure respect for free expression through independent judgment. No? So Facebook now, if you notice, it has its own community standards, but so there would be a different community standard in the Philippines as opposed to say in Nepal or in Iran. Now, of course, despite the creation of this oversight board, there have been a lot of criticisms among many sectors in civil society. There's the sense that Facebook is not really doing enough. So, as a way of actually providing a further check on Facebook, some sectors have put up what they call the real Facebook oversight board, but they draw attention to the continued failings of Facebook and its oversight board. Now, by the way, the oversight board, it's a uh, it's a paid position, and just recently, I think two weeks ago, they started hearing cases. So they act like a private court, and they look at all these appeals made by posters. And here you see exactly how this triangular model of free speech regulation works. Another illustration of how this model is being worked out in real life is the right to be forgotten. In 2014, the European Court of Justice established a two-step process to enforce this right to be forgotten. So it required Google to have its own private administrative procedure for hearing requests, for removal of links or electronic data pertaining to a person. No? And now people are required to exhaust this private administrative procedure. And if they disagree with Google's decision, that's when they can go to courts. And in 2019, it even further delimited what may be done with respect to this right to be forgotten. And again, this is also a pragmatic decision. So if you're a European citizen and you want to enforce this right, you can only force Google to do that within the bounds of the European Union. If there is any article, any data about you posted in a site in the US, that will be outside the jurisdiction of any European court. You see here a fascinating institutionalization by European courts of a private administrative prior restraint mechanism. Now, there's another important issue dealing with social media, and that's the question of intermediary liability. So, how exactly would questions of responsibility be resolved with respect to third party content? One proposal for that is the notion of a fiduciary trust, and that trust has been embodied in a set of principles that were first elaborated in the Philippines in 2015. So there was a gathering in the Philippines in 2015 of different stakeholders, and they proposed these principles to govern how governments and social media platforms should look at intermediary liability. And there are six such principles. The first one is that intermediaries should be shielded from liability for third party content. Content must not be required to be restricted without an order by a judicial authority. Third, requests for restrictions of content must be clear, be unambiguous, and follow due process. Fourth, laws and content restriction orders and practices must comply with the tests of necessity and proportionality. Fifth, laws and content restriction policies and practices must respect due process. And finally, transparency and accountability must be built into laws and content restriction policies and practices. Earlier, we said that there's a tendency in Philippine jurisprudence to zero in on individual rights as the basis of free expression. But we have, of course, what you may call breaks in jurisprudence, breaks that advance or that expand the boundaries of our understanding of the scope of free expression. And this is one such case, the Diocese of Bacolod versus Comelec. In this case, the Supreme Court actually expanded our understanding of the whys and wherefores of free expression. Uh, First, the court said that free expression deals with the right of the people to participate in public affairs. And second, free speech is important to the marketplace of ideas. Third, it also involves free self expression that enhances human dignity. And fourth, expression is a marker for group identity. So it's not just individual rights, but it's central to the formation of identity and community spirit of groups, of institutions, of voluntary associations. And finally, free speech is also important for the protection of individuals and minorities against majoritarian abuses. So, because democracy is not just really the rule of the majority, but it's the coordination of the different interests in society, which includes the right of vulnerable individuals and minorities. Now, the consolidated case of Decini versus Secretary of Justice 2014 presented a host of challenges to the Philippine cybercrime regulation. And an important holding of the court here deals with cyber libel, in that the court actually expanded the actual malice test. According to Decini, even if a journalist is grossly or extremely negligent, the journalist is not automatically guilty of actual malice. In other words, the court actually set a very high bar for conviction in cyber libel, given given this holding of the court. Secondly, and this is relevant to our earlier discussion on the Manila Principles. No, there's no intermediary liability in cyber libel. So according to the CINI, sharing or retweeting is not actionable in libel. It's only really the original post that's actionable. We also have these important holdings of the court in the same case, now dealing with the takedown clause and the real-time data collection provisions in the Cybercrime Act. So, according to the court, these will require court orders. So it struck down Section 4 penalizing the posting of unsolicited commercial communications. Section 12 that authorizes the collection or recording of traffic data in real time. And Section 19 that authorized the DOJ to restrict or block access to suspected computer data. Now, a recent development in relation to this is the Budapest Cybercrime Convention. The Senate ratified this treaty in 2018, and it requires legislation, among others, on seizure of real-time collection of traffic data and interception of data. A relevant provision of the treaty is where a party, due to the established principles of its domestic legal system, cannot adopt the measures, it may instead adopt legislative and other measures as may be necessary to ensure the real-time collection or recording of traffic data associated with specified communications transmitted in its territory. It's fair to say that the Decini case will have to be considered by Congress in crafting a law dealing with the real-time collection of traffic data and interception of data pursuant to the Budapest Cybercrime Convention. By way of conclusion, I would like to read this quote from the German philosopher Ulrich Habermas. And this quote, to me, encapsulates the continuing challenge of social media to free expression. It's true that the internet has reactivated the grassroots of an egalitarian public sphere of writers and readers. It also counterbalances the deficits from the impersonal and asymmetrical character of broadcasting insofar as it reintroduces deliberative elements in communication. Besides that, it can undermine the censorship of authoritarian regimes. But the rise of millions of fragmented discussions across the world tend instead to lead to fragmentation of audiences into isolated publics. Thank you very much, and a pleasant and good afternoon to everyone.